Hey, good morning, everyone in U.S. government and political science. I wanted to put up a video about the courts. We finished up with the most important leg of government, at least in terms of what our framers thought in terms of lawmaking, being the legislature, and then the executive, the one that enforces the law, and has other roles as well: chief negotiator, foreign affairs, commander-in-chief of the military, uh, the appointing official of administrative agencies and other federal agencies, and the appointment of judges with the consent of the Senate. All very important positions in the government. The third branch of government, the judiciary, wasn't clearly as defined in the original constitutional documents. And even in the Federalist Papers, when you look at it, what the courts would do was recognized really as, well, they were going to interpret law and resolve conflicts both in fact, which is the trial court, and in law, errors of law, which would be the appellate court. They would have that jurisdiction. And we have a very complex system because we have federal courts, federal law, and we have state courts and state courts and state law. They are independently run, and sometimes they overlap. Something that could be a violation of law could be a violation of criminal law in the federal system. It could also be a violation of criminal law in the state system, and the jurisdictions might overlap. We know because of the supremacy clause in the United States Constitution, if there's a conflict between the two entities or two legal standards, federal law preempts state law. When in conflict, they can coexist as long as they're considered ancillary to one another and not necessarily in conflict. What we want to talk about is the third branch of government. And we've been taught, and I brought this up in the other mini summaries of the presidency and the legislature, that many people have stated that we have three co-equal branches of government. This I have to disagree with. I don't think it was an intent to make them equal, of the same value and quality and importance. But over time, because the court developed something called judicial review, giving the recognition that a court can strike down a federal statute or an action of the president as unconstitutional, thereby being a check against those two branches and seemingly having significant power. Many people interpreted that as being a co-equal branch of government. I don't like that definition, but I do like the definition that is a third branch of government that acts in checks and balances with the other two branches. How so? I just alluded to it with that famous case of Marbury versus Madison. In that case, I think the most significant judge that ever sat on the Supreme Court, a guy by the name of John Marshall, and the other members of the court made a ruling that if a law being interpreted by the court is deemed to be in conflict with the Constitution, that law is a nullity, it's void. That was the first case dealing with a federal statute, an act of Congress. Later, it would do things like rule that an act of the president was unconstitutional and therefore null and void. And then in later cases, it would rule that state laws in state actions might be in contravention of constitutional principles and therefore null and void. So although not written directly in the Constitution and maybe not meant at its inception in terms of what the forefathers intended, over time, the court has become significantly powerful because of that ability to strike down laws, both state and federal, actions of both executives, governors on the state level, president on the federal level, as unconstitutional. It's given the court a significant amount of power. But what was and what is a court? What's it for? Obviously, we want to create a system that is predictable, that is peaceful, and that is accessible to resolve conflicts between individuals, between companies and individuals, between governmental entities, state versus federal, even bureaucracies within the federal and the state that come into conflict. There needs to be a method to resolve these things. And who do we take it to? Who's our arbitrator of conflict in order to keep a peaceful society? It's going to be the court system. We have both civil law and criminal law. The difference, and although the book does get into a little bit, and you should know the difference, civil law is largely things that aren't going to rise to the level of being a moral detriment to society as a whole. That's what a crime is. Something that's deemed harmful to society as a whole. The victim is us, the people. So that's why I often hear a charge saying the U.S. versus someone. That's often a criminal case, or the Commonwealth of Massachusetts versus Joe Smith. Not always, but often, just by that moniker, that caption, we often recognize that as a criminal case. Crimes are basically acts that are deemed to be harmful to society as a whole. Civil actions are private wrongs and duties flowing back and forth. Contract disputes, family law disputes, contracts over or disputes over property rights, all of these things are considered civil in nature, and they're sometimes between the government and an individual, or government and a company, but also times considered private wrongs and private obligations that are going to be ferreted out through the court system. Most importantly, what I want you to know is the basic structure of the federal court system, and just by way of illustration, I'll talk about the structure in Massachusetts, which in many respects is very, very similar in terms of its trial court system and appellate court system as the federal level structure. Very, very similar. So let's just talk about the federal, and that's what the book's going to focus on anyways. Every federal, or every state in the United States has a federal district court, at least one. Massachusetts has 3. A district court is the court that we consider court of general jurisdiction. If you hear general jurisdiction, that means it hears a wide array of federal matters. To get to federal court usually has to be a federal question. There is a major exception called diversity jurisdiction. That's when a citizen of one state is suing a citizen of another over a civil matter, like a breach of contract or personal injury or product liability, in the cases worth more than $75,000. That diversity of citizenship allows people to sue in federal court. That's a very small fraction of the types of state cases that end up in federal court. Most cases that go to federal court have to go there because it deals with a federal question. Federal statutes in play or federal rights under the Constitution are the topic of the dispute. So every state has at least one federal district court. Massachusetts happens to have 3. That's where a case starts. The name of it's the Federal District Court. We also call it the Court of Original Jurisdiction. Why? That's where the case starts. That's why we call it original jurisdiction. We also call it the Court of Record because that's where the record of the testimony and the evidence that's going to be submitted would start. Court of Original Jurisdiction, Court of Record means the same thing. They're all synonymous. What's interesting about the system, it's not that much different than the state court system. But what we really want to stress at the trial court level, what happens at the trial court level? Evidence is produced, testimony is given, documents, exhibits. All of these things are submitted at the trial court, which is in the federal system, is the Federal District Court. We determine if it's a jury trial. The jury determines what facts to believe, what weight to give different factual presentations, whom to believe, who to discredit. And it's the jury that's the sole determiner of the facts, what's to be believed, not to be believed, and as to what weight they're going to give what testimony or what evidentiary issues that come before them. The judge is the gatekeeper as to the law. They instruct the jury on what the law is, and upon finding the facts to be whatever they find them to be, they apply the law as the judge instructs. That's true both in the criminal realm as it is in the civil realm. Now, many times we don't have jury trials. Either the jury is waived, we decide we just want a judge trial, maybe it's a very technical issue that we have before the judge, or we just think we're going to get a quicker resolution to the case if we get before a judge, or maybe the judge is just well known to both sides in the litigation and we think he or she is going to be very fair, because jury trials are very expensive and time consuming and, well, I think a little less predictable than some judges that we get to know over time. In a criminal case, the defendant always has a right to a jury trial. It's in the 6th Amendment to the Constitution. We already talked about that from a previous chapter. The defendant has the right in a criminal case to say, I want to go in front of the judge. The facts of this case are very, maybe they're very salacious or they're very controversial, and you want the judge to apply the law in a stricter fashion. You don't want some of the upsetting facts that are true, but don't necessarily show you're guilty of the offense, but make you look terrible, in terms of what are some of the things you were involved in. Maybe you want to have what we call a bench trial or trial just in front of a judge. Again, always the decision of the defendant. And the prosecution has no choice over it. It's the defendant's right to a jury trial or a bench trial. If it's a bench trial, the judge will not only apply the law as he or she determines to be applicable to the case, but they're also going to be the fact finder to determine what the facts were as a result of the evidence they hear. That's true in the state of Massachusetts, as it is true on the federal level, because the federal government dictates that the Sixth Amendment is applicable to the state. So even in Massachusetts, the defendant has a right to a jury trial for all criminal cases, and it's the defendant's right to waive it if they want to just have a trial just in front of a judge. Now, in a jury trial, although it's not directly in the Constitution, it's been understood in the principles at the time of the adoption of a case that for criminal cases, the jury must be unanimous. They must unanimously agree you're either guilty. Don't say innocent. Everyone says that. I was found innocent by the jury. No, you're found not guilty. It means you still might have done it. Jury wasn't convinced by proof beyond a reasonable doubt, which is a very, very high standard, that you were in fact guilty of the offense. That's true in the federal level and on every state level. There's no state jurisdiction that has a criminal jury process that's less than unanimous. It has to be unanimous. And so it's a big right to give up for defendants, but sometimes they do. I do it in my own practice. I'll have a defendant and I'll say, we've got a very good judge here. The case involved, and here's a very technical question, and I don't think technically they can't prove it. Jurors are just going to say, well, we think the person did something wrong. Let's stay away from a jury because they're not going to be as knowledgeable about the nuances of the law. Let's go jury waived. It's up to the defendant, of course. It's not my decision. It's the defendant's decision, but sometimes I'll advise him to go jury waived. Now, what happens again at the trial court, whether it's a jury trial or a judge trial, which we call a bench trial, either in the state or the federal system? Facts are determined, law is applied, and a verdict is rendered. What I really want to drive home is every court system, whether it's federal or state, has an appellate process, meaning the losing side can say, I think I've been wrong. There's an error. I want to appeal my case. The problem that I think that most of society has in terms of knowledge when it comes to the judiciary is they think they can appeal every losing matter. Well, you can appeal it, but what do you have to cite? Do you say, I can't believe the jury thought I robbed that bank. I want to appeal. That's not a valid appeal, believe it or not. It has to be about law. The appeal has to be about the interpretation of law or the conduct in which the trial was done, creating an error of law, not a fact. So you don't appeal that the jury got it wrong, that the person did the crime, or the jury got it wrong, that I entered into a contract. What they got wrong is understanding the elements of what the legal standard was for a contract, or they misunderstood the evidentiary instructions that were given to them, or the jurors knew the alleged victim in the case, and therefore they had bias and they shouldn't have been allowed to sit on the jury. That's an error of law. So purposes of test questions, you should understand that appellate courts hear issues of law, not a fact. They determine what the fact is at the trial court, the court of record. They review the transcript at the appellate level. No new witnesses are testifying up there, and they just determine whether the law and the procedures were followed appropriately, alleged errors of law. Well, that brings up the important question of the Supreme Court. Why is the court sort of the third branch of government, especially the Supreme Court? We think of the presidency, we think of the legislature, and then we think of the court, especially the Supreme Court as being this third prong and mix of checks and balances between each branch of government. Because the Supreme Court is mostly a court of appellate jurisdiction, they usually hear matters that were already tried in a trial court, may have even gone to the Circuit Court of Appeals, this is an intermediate appeals court. And if it ends up at the Supreme Court's going to determine whether the law was interpreted and applied the correct way. Why the Supreme Court's so important is not only because of the final arbiter on what the federal law means. Well, what's the biggest federal law we have? The United States Constitution. Because of Marbury versus Madison, when anybody's arguing the Constitution means this or the Constitution means that, it's the Supreme Court in a controversy that's been tried in a lower court. It gets up to them. They determine what the law means, including the law embodied in the Constitution. The Constitution is one massive law. And so things like the Roe v. Wade decision was a decision about whether the Constitution provides for a woman's right to privacy in the first trimester of her pregnancy to determine whether or not she wants to abort that fetus or not. That's a question of law under the Constitution. And so when the court decided, yes, a woman does have a right to an abortion in the first trimester of a pregnancy under the Constitution, is that now the law of the land? Yes, it is, unless what? We amend the Constitution or we get the court to change that view on a future matter with the same question. That's kind of rare. Why? Because stare decisis. And this is what I want you to know for the test. Once the appeals court makes a decision about the Constitution means X, Y, Z, or the Constitution means that, or the Fourth Amendment means this, or free speech under the First Amendment means that, the court tends to let the matter rest, meaning that's what the law is now. We usually follow it as a nation. People get upset about it, but they live by it. They recognize that's the current status of the Constitution. Sometimes we amend the Constitution as a result of it. That's like the 11th Amendment, for example. We used to allow one citizen of one state to sue the other state as a state in the Supreme Court. And it's crazy. Lawsuits are coming all the time. I'm going to sue the state of Georgia. Someone else is going to sue the state of Maine. And you can do it right in the Supreme Court. The 11th Amendment banned that because we recognize that the Supreme Court said that was allowable, and we can undo what the Supreme Court says if we're willing to amend the Constitution. So some people that are anti-abortion, for example, want to amend the Constitution to basically nullify the effects of Roe v. Wade. That's the only way to do it, or get the court to overturn Roe v. Wade in a follow-up decision. But they usually don't do them within a short period of time. Roe v. Wade was 1973. And why was there some excitement over this most recent set of justices being put on the Supreme Court? Is they're new. They're new Supreme Court justices, and some people either worry or applaud that these new Supreme Court justices might have a view contrary or consistent with Roe v. Wade. So it gives both sides of that issue either hope or fear that prior decisions might be overturned. But courts don't willy-nilly just flip decisions. It takes many, many years usually for the court to evolve, to change a philosophical position. It takes a change of membership, and it takes a new controversy under the principle to be brought before the court. In the example I used from the 14th Amendment assignment in your book and your homework is that for a long time, all the 14th Amendment was determined to provide was separate but equal. So African Americans had a boxcar on a train system that was relegated to only African Americans, and they had another boxcar that was relegated to only to whites. Some African Americans sued, saying that's a violation of the 14th Amendment, equal protection of law. And the Supreme Court in 1896 said, no, all it says is what? The laws have to be equally applied. So if you have the same kind of boxcar as white people, the law has been satisfied. That lasted all the way until 1954, when Brown versus the Board of Education saying segregation in schools, by just the nature of segregating them, you violated the 14th Amendment. You can't have separate but equal. You create inherently unequal situations. Basically, they did what? They overturned Plessy versus Ferguson. And how many years was that? 1896 to 1954, you've got 60 years. It takes a long time. So people that are rooting and hoping for the overturn of Roe v. Wade look for new members to come onto the court. They look for a change in philosophical outlook by the court, and they look for time passage to go by and hoping the court changes its position. And that's why it becomes so important, the process by which somebody becomes a member of the Supreme Court. There are 9 people on the Supreme Court. Nowhere in the Constitution does it say there'd be 9 people. It's custom that one time there was 13 members of the Supreme Court, very early on, before the court, Marbury versus Madison, came out. But we've had a long-standing history of 9 members in the Supreme Court. And then the Supreme Court made some very unpopular decisions in the 1930s. And if you know a little bit about this story, it's one of my favorites. FDR, Franklin Delano Roosevelt, there was an era of depression in this country, financial depression. People were very desperate, over 25% unemployment rate. And so Congress and FDR tried to create all these different programs to trigger the economy, get the economy primed to get people back to work, create social welfare program to help the very poor and indigent get back on their feet. And some people challenged it. Some people didn't like it. And it went to the Supreme Court. What did the Supreme Court initially say about a great many of FDR and Congress? They were together in agreement that these laws should go forward. Supreme Court shot them down. Says, you guys don't have the power to do that. It's not that it's a good law. It's not that it's a bad law. It's just that it's unconstitutional under the powers that the Constitution grants to Congress and the presidency. So what did FDR do as a result of this frustration with the Supreme Court making rulings that said the Constitution didn't allow for those kinds of programs to be implemented? He did something called court packing. This is going to be on the test. Court packing is basically saying what? We've got 9 members of the Supreme Court. I want to expand it to 13, 15, 19, whatever it is. And his excuse was because we had so many older members of the Supreme Court, we don't want to leave it in flux in case people die off or get sick. We want to make sure we have a very stable court with more members. But basically, what he was trying to do is what? So, yeah, there's 9 members on it now, but only a couple of them are agreeing with my vision as to what the Constitution allows. If he puts 5 new people on, or 7 new people, or 12 new people, who do you think they're going to be? They're going to be, I won't say cronies, but they're going to be allies of his. And I don't blame any president. I don't care if it's President Trump or Biden or anybody. Presidents are elected to appoint people to the court. And when they do, we shouldn't be so shocked that they pick people that have a philosophical outlook that's similar to their own. That's part of the cost of winning and losing elections. But most recently, Trump has put on 2 Supreme Court justices, really 3, during this period of time fairly quickly, very conservative justices. And a lot of people that are on the more liberal spectrum of politics are very, very upset. And some of them, with the most recent one, Amy Barrett, was at the kind of the very tail end of the election cycle. And people said that was unfair, it should have done it because they wouldn't let Obama. Basically, the Senate had blocked Obama's potential pick, this guy named Garland. And so people were upset and says, hey, Biden, when you get in, you should pack the court, doing like what FDR never did it, by the way. He said he was going to do it, but he backed off because public opinion was so anti that kind of power grab. And I am also a big believer that Biden shouldn't do it. Even if we have justices we don't like, that's the consequence of our constitutional system. New president shouldn't be able to come in and say, well, I don't like how the court is made up of right now, so I'm just going to put a whole 7 or 8 or 9 other members on to make it more politically favorable to my political position. Elections have consequences, and that's the kind of nation we live with. And I don't think anybody is going to get away, whether it's liberal or conservative, with packing the court. But what's interesting is why is it so important who the president puts on? Well, there is a check on the president. The president can't put anybody on they want. The president picks them. They have to get consent of whom? Which branch? Don't say the whole Congress, just the Senate. But the Senate has historically put pressure on the president to pick candidates that are going to pass that review by the Senate. So a lot of people say, oh, whoever the president picks always gets approved by the Senate. Well, don't you think the president is well aware that if he picks or she picks somebody who's really on the extreme spectrum of either skills or philosophy, that they're going to have an obstacle from the Supreme Court, from the Senate, and so they tend to pick people they know are going to pass, and that it doesn't go through controversy and there's hearings and the public gets to watch these judicial nominees basically ferret out their skills or experience and their philosophy to some degree. The process does bring integrity to it, and there have been some, and the book goes over 3 or 4 of them, who one actually got voted out. They didn't get the majority vote to become a United States Supreme Court member. Others, after being initially nominated by the president, had to withdraw their name because they recognized the Senate was, in uproar over their nomination, and they wouldn't likely be confirmed. And so there are checks and balances in the system. So what's the check and balance on the Supreme Court? A lot of people say, oh, there's no check on the Supreme Court. Once they're in, I agree. There's very little check on the Supreme Court once they're in. You can impeach them, but they have to do what? Commit high crimes and misdemeanors. So as long as they're not committing crimes and doing overt wrongdoing or corruption, Supreme Court members stay on the bench for how long? Life, unless they decide to retire early. Some have. Sandra Day O'Connor, I think, had a husband that was in ill health, and she retired while she was still healthy. The Supreme Court Justice Kennedy retired while still, vibrant mentally, and he wanted to retire. He wanted some time off. Other justices have stayed right through death. They die on the job. Scalia, the most recent, although he was fairly robust, and he just had a massive heart attack while he slept, I guess, when he died. And others stayed on the court probably too long. They were very sickly, maybe even had dementia. There's no mechanism to remove them. That's been done in the past. We've had, I don't want to name justices' names, but there have been some justices that probably were in significantly diminished mental capacity near the very end because it's a life appointment. And so people say, well, it's a life appointment. There's no check on them. That's not entirely true. There's some political pressure to make decisions that the society as a whole are going to find palpable or palatable and are going to accept them as legitimate, so they can't go too extreme on any decision. There's always political ramifications from the decision. And the other is what? The other is the fact that if the people really do get up in arms over a constitutional interpretation by the Supreme Court, what can we do as a people? We can amend the United States Constitution. And that's been done. We have amended the Constitution to create different interpretation of what the law means and implies, therefore checking the Supreme Court. One that a lot of people don't talk about is, because it's seldom used, and I got to admit, I think society might kind of blow up over it, is that the Congress actually controls the jurisdiction of the courts, meaning that if the Congress wants to take away certain kinds of cases from the Supreme Court, even hearing them, they actually have the power to do that. They've done it a few times throughout history, but they rarely touch it because it's weakening one branch of the government that acts as a check on the unwieldy, maybe unconstitutional Congress. And the same with the president. If the president goes off the rails, the court can shoot down what the president's doing as unconstitutional. Again, it's only about whether it's constitutional or not. It's not whether it's a good idea or a bad idea. And this kind of happened not that long ago. To me, it's not that long ago. The Affordable Care Act, what some people call Obamacare, it went up to the Supreme Court as to whether or not it was constitutional or not. And Justice Roberts, some people consider to be a fairly conservative justice. He was appointed by Bush. He's the Chief Justice of the United States Supreme Court. And during all the hearings, there was all these people, like as if it's not about popularity. And that's what people get mixed up with. They think the Supreme Court's trying to do what's popular. They're just trying to decide whether something's constitutional or not constitutional, not whether it's a good idea or a bad idea. And unfortunately for those people that really liked John Roberts as a conservative, they got very disappointed because John Roberts, with 4 other members of the Supreme Court, all you need is a majority, 5 of the 9 said that the Affordable Care Act was constitutional as a taxing tool under Article 1, Section 8 of the Congress's power. They could do it. And a lot of people said, oh my God, John Roberts turned liberal. I don't buy that argument. It's not about liberal or conservative, about whether it's constitutional or unconstitutional. Now, you should know a little bit about decisions when decisions do come down from the Supreme Court. Early in its history, the court wanted to often have unanimous decisions. Unanimous means all 9 justices agree that the law means X, Y, Z. It's clear as day because they wanted to get that buy-in. So when a decision was made with a unanimous decision, it arguably set the precedent, if you will. We knew the nation was going to accept it as the true interpretation of the law. That changed over time, and certainly in the 20th century, now in the 21st century, it's not uncommon for justices to dissent. They don't agree with the majority, but why bother? What if the decision 6 justices agree the Constitution means this, 3 are in dissent? Why bother writing a dissent? Why bother letting the world know you disagree with the majority? It's because the dissent today could get political favor over time and could actually become a majority decision later on if articulated well and shows a lot of reason and rational basis and strong interpretation. And that's happened in our society. For example, in Plessy versus Ferguson, one of the justices, I think it's Justice Harlan, he said it was outrageous that African Americans and whites are treated separately in accommodations, creating an inferiority, complex inferiority set of standards in terms of just being by the very nature of being. That's actually what the majority ruled in 1954. They basically adopted the dissent all the way back from 1896, even though Justice Harlan had long since died. So a dissent is a powerful tool. It helps you understand the majority's decision a little better, but it's also a powerful tool for further pushing and pressuring the court to review and modify what the majority decision says. And now, historically, right now, we've had more and more decisions being 5-4. And all it takes is a majority decision to make a ruling. It is binding law going forward. And what do I mean by going forward? It creates the precedent. The precedent means an under stare decisis. If that legal question comes up again in the lower courts, what do we have to follow? The Supreme Court majority ruling that was previously made on the same legal question with similar factual background. Very powerful tool. It gives us predictability in the law. For example, in Massachusetts, I know what the Supreme Judicial Court said about the appropriateness about searching someone's motor vehicle just based upon a civil motor vehicle citation. They create a case, they make a ruling that that's not a legal search without consent. So now the next time I have a search of a motor vehicle based upon just a civil motor vehicle citation, I'll argue that that's unconstitutional. And the judge goes, well, why? Based upon what? I'll bring up that old case from the 1990s saying that just based upon a civil motor vehicle citation, it would not be grounds under our state constitution or under the Fourth Amendment to the United States Constitution as an appropriate triggering for the police officer's right to search the motor vehicle. So you see my point? It establishes the principle, and we look to the previous law called the common law, the history of rulings over time, in order to give a predictable future. It's a very, very fascinating process, that being on the Supreme Court and what the Supreme Court role plays. If you ask me who's the most important person, in terms of political power in the United States, I'd always say the president. But then somebody say, who would be next? Would it be the vice president? Would it be the Speaker of the House and Congress? Or would it be a U.S. senator that's the majority leader? No, I say the president's first, and then we have 9 people next, and the 9 people next would be on the Supreme Court. And that's why I think it's important when you vote for the president, you have to consider what kind of justices they would put on, because you don't know when a justice is going to die, or surprisingly, when a justice is going to retire. Now, some of you might be curious about Massachusetts. I'm not going to test on Massachusetts, but the Massachusetts court system is somewhat similar. Our trial court system, we have multiple trial courts in Massachusetts. Federal has one. Well, I should have one. It has the bankruptcy court, the court of international trade, the tax court, the bankruptcy court. There's several specialized courts in the trial courts in the federal court, but the main one is the federal district court. They hear the broadest array of cases. In Massachusetts, we have several trial courts. The biggest one, the one that hears the broadest amounts of claims, or can hear the broadest amounts, would be the Superior Court in Massachusetts, followed by the district court. The district court in Massachusetts hears almost all the similar types of cases, period, just less significant. Misdemeanor versus felony on the criminal end, and on the civil end, usually cases worth less than $25,000. Then we have other courts of specialized jurisdiction, the probate and family, dealing with probate and family issues, the juvenile court, dealing with juveniles, the housing court, dealing with landlord-tenant issues, the land court, which we can do most things in the Superior Court as well, title disputes over real estate, probably forgetting one off the top of my head. Small claims court is very important, but that's a subset of the district court. Housing, I mentioned, probate and family, divorce, all that good stuff. Those are trial courts. Again, what happens at trial court? Facts are determined, the law is applied. And then we have, just like in the federal system is called the Circuit Court of Appeals. There's, I think, 13 regions in the United States have 13 circuit courts. We live in the First Circuit for the federal. In Massachusetts, we have something called just simply the Court of Appeals. Usually go there next if you think there was a legal error in the case. Then in Massachusetts, we have the Supreme Judicial Court. That is the highest court on our state law questions, not federal law. You can bring federal law questions, believe it or not, through the state court, but it's not the final arbiter. The federal court is the federal arbiter of federal law. You can't usually hear state law questions in the federal court unless you have that diversity jurisdiction thing I talked about. In Massachusetts, how do you become a judge? Well, let's talk first. I think I made it clear. How do you become a judge on the federal system? On the federal system, the president nominates you, and the Senate either approves or disapproves you, and they have hearings. Judges in the federal system, on the Supreme Court level at least, are appointed for life, and most of the district court positions are also for life. Some of the judges in the other courts might have a term of years, like a 7-year appointment, a 10-year. I don't know that many federal court judges, so I don't know how their system works, but generally it's a lifetime appointment. Why you'd want to work forever as a judge is beyond me, but if I'm the Supreme Court, I would, because you're making policy about what the United States Constitution means, and I think that's hugely significant, very powerful position. That's why sometimes people hold on to it right to the end. Just a quick story in terms of holding it right to the end. The first African-American justice we ever had on the Supreme Court was a guy by the name of Thurgood Marshall. Thurgood Marshall actually was the attorney that argued the Brown versus Board of Education case. Well, he sat in the Supreme Court for a long time, had a very long history, career, fought for civil liberties and civil rights while he was on the Supreme Court. But when he retired, he was very, very frail and very sick. He held out as long as he could. He wanted to stay on the court as long as he could so he could fight for the values that he thought the way in which the Constitution should be interpreted. When they wheeled him out for his little retirement thing in the press conference, he was getting pretty tired and pretty cranky. And he looked very, very sickly. He was kind of slouched down and he was kind of in a wheelchair. But his mind was still good, but he was really tired. And they asked him, "Why are you retiring?" And he just kind of looked up and he says, "Why am I retiring?" And he said some swears. He says, "Why do you think I'm retiring? I'm falling apart, you idiots." I thought that was really funny. But, sometimes it's obvious. You're very sickly, very old, and you retire. But others retire, relatively young and healthy. Justice Souter, who I think lives up in New Hampshire, he retired like in his 60s. Everyone thought he would stand for a long time. He just lost the drive to do it. In Massachusetts, it's a little different. When you get appointed to a judge in Massachusetts, not by the president, it's by the governor. Now, the governor will pick you, but does our state legislature approve or disapprove you? Is that the check we have in our state system? Actually, our state's a little unusual. We have a special body called the Governor's Council. It's an elected body. There are 13 in Massachusetts, 8 or 13, I can't remember, but there are districts. I think we live in the 7th district. Our current Governor's Council, a guy named DePaulo, he literally sits in Boston one day a week. Governor will pick people to sit on the judiciary, all the different levels of the judiciary in the state system. He will appoint people to become judges and clerk magistrates and jobs related to the judiciary. And it's up to the Governor's Council to have hearings and determine whether these people should be approved or disapproved. That's a little different than the federal system. But once approved in Massachusetts, here's the big distinction. And I think it's a violation of the law, Constitution. You only serve until the age of 70. It's mandatory retirement at the age of 70. There's a provision in the statute that these judges can be brought for callback for periods of time. I don't know if it's for months or for just rotating basis if there's a shortage of judges to serve continually, but you're technically required to retire at the age of 70. Just a quick story. The judge, actually, I respect a great deal, but I always a little afraid of him because he's very serious and very formal. I remember that I was actually stopped into his little retirement party in the court there in Cake, and it's about 3 months later, and you don't know who you're always going to pull for the jury trial. So you start in one court, and they say, well, we're going to send out your case to courtroom number 17. You'll have a jury trial there, Mr. Corman. I said, thank you. I'll go down there. You're wondering which judge is going to be in courtroom 17, and you go through the door, and you ask the court, hey, you know who the judge goes? Oh, we don't know yet. We don't know. And all of a sudden, who comes up with this judge who just retired like 6 months ago? And I actually had fairly good luck with him, but I always felt intimidated by him. And when he came out, I was like, oh, come on, I thought this is mandatory retirement. And he's still doing it to this day, as a matter of fact. But that's kind of an interesting system. But the judiciary does what? It interprets law. So just like in Massachusetts, just as another quick example of how sometimes things surprise people, although it's not as controversial it is today as it was 20 years ago. In Massachusetts, a lesbian couple, a gay couple in Western Mass, one of them being a law professor from the law school I went to. I never had her as a professor, but she wanted to marry her significant other. They were both female, and they went to get a license, and they refused to get a license. You can't marry as a lesbian. So they sued and went through the court system. Trial court denied them. They went all the way up to the Supreme Court of Massachusetts, and they tried to argue not under federal law, but under the state of Massachusetts Constitution, that equal protection law meant also if you were identified as a class of people, gays, lesbians, heterosexuals, you're all entitled to the same rights and privileges. One of the things that are a fundamental right in our society is the right to marry. And they convinced the Supreme Court of Massachusetts that gays and lesbians under the state of Massachusetts Constitution have a right to marry. That became the law in Massachusetts. And then I remember a lot of people who were anti that decision. People I knew too goes, well, they should take the case to the Supreme Court of the United States. Supreme Court of the United States interprets what? The federal Constitution. They had no jurisdiction or standing, and that's what makes our system of federalism so complex between state and federal. A lot of people get tripped up over that, and it happens a lot. Sometimes some state will say something like, I think there was a controversy not that long ago on a Netflix about somebody. There was some quasi-documentary about somebody getting railroaded in a judicial system and got convicted or something like that, and a lot of people wrote in and petitioned President Obama at the time to pardon this individual. What's the problem with that? It was a state of Oklahoma or something like that case, and the president can only pardon people for what? Which is coming up in the news right now. President has an unlimited capacity to pardon people for any what? Federal crime. The president can't pardon people for state crimes, and vice versa. The governor of Massachusetts can pardon people for state crimes, but has absolutely no authority to pardon people for federal crimes, even if committed within the bounds of the state of Massachusetts. So there's a controversy right now. I don't think it's that controversial in my book, because that's the power we've given the president. We have President Donald Trump right now, and he looks as though he has lost the election, and it's going to be Joe Biden. A lot of people say before Trump leaves, he might drop a whole bunch of pardons for his family, his friends, his political allies that served in his administration. And, a lot of people are outraged. I'm not so outraged, and it's not because I'm a Trump fan. Why am I not outraged? The Constitution gives him that power. If you don't like it, take it away. I personally think the president should have powers of pardon, and I also think the governor of Massachusetts and governors of other states in their state constitution should have certain power. Because what is the power of pardon? Isn't it a check on government overreach sometimes? Sure. Could it be abused? Like any right, any privilege, any power, it could potentially abuse. The one thing that keeps the abuse to a minimum are the checks and balances we have in our system. And maybe at some point, if the pardon process becomes abused, we might do something and change it if this happens in the near future. But over time, I don't think the power of the pardon has been abused by anybody up until this juncture. And some of you can disagree with that, and I know some of you have, and some of my friends and lawyers have believed that President Trump has already pardoned some people inappropriately. But that's the power they have. There's no appropriate, inappropriate. It's a power that's been given in the Constitution. But that's the court in a nutshell. I urge you to go visit the court in Massachusetts, by the way. Physically, it's real beautiful. The Supreme Judicial Court of Massachusetts. It's a great place to look at. And get down to the Supreme Court if you've never been. I might go someday. I've never been to the Supreme Court other than visiting it just as a kid in college. I went down there. But I want to do this little formal thing. If you're a member of good standing in the state of Massachusetts, attorney, which I am, you can apply and become sworn in to practice before the Supreme Court of the United States, and usually get to meet one of the justices and maybe all of them in the back room during one of their days of hearing. They do this little ceremony for attorneys that want to become sworn in before that body, and you can meet the other justices, get your picture taken, like with rock stars of the judiciary, if you're into that kind of thing. But to me, the jury system, the court system, the transparency, that public trials for the most part, in almost every kind of case, it's really what keeps us free from a tyrannical government. A lot of people think, oh no, what keeps us free from tyrannical governments are checks and balances. But the court system, the jury process, the integrity that we have in being tried by an impartial juror in your community, I think really does keep us free from an unwieldy governmental authority that may be out of control. But that's just my own two cents. Be well, everybody.